Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to this episode of Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice. The Florida Bar Association says I have to say it, so I've said it. But nothing will ever stop me from giving you an easy-to-understand overview of the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Are you disabled? If so, today's podcast is for you. If you're disabled but not ready to apply for your benefits, you can still learn lessons from this podcast. I'm going to talk about 4 things today: ERISA versus non-ERISA and associated short and long-term disability benefits, disability and exclusions and limitations, overviews of the claims process, and I'm going to answer that question I get all the time. Do I need an ERISA disability attorney? Let's take a break a moment before we get started. Welcome back to Winning Isn't Easy. Let's talk about the disability insurance claims process. But before we even start talking about filing the claim, there are some things I think you need to do before you make the decision to stop work and to apply for benefits. Many of these things you can do for yourself before reaching out to an attorney, and these include reviewing the policy. What does your policy say about the definition of disability or occupation? What are the limits, if any, and there probably are, on the nature of the benefits that you can get or the period of time you can get those benefits? Next, review your medical records. I will promise you very few people get their medical records and review them before they make the decision to stop working. And you'll be stunned at the stuff you'll see in your medical records. And it might be that you have to find a new doctor, because the third thing you've got to consider is whether or not your doctor supports your claim. They may take an accurate history, they may be a great provider, they may be sympathetic, but if they aren't willing to fill out disability insurance claims, your ERISA disability insurance claim will go nowhere. So you've got to determine the level of support of your physician. Now, this is where it starts to get a little more complicated, because you have to obtain proof that your symptoms meet whatever the standard of disability. In other words, it's not just enough that you have back pain or that you have leg pain or you can't sit. You have to establish that you have an objective basis for the diagnosis, an objective basis for any restrictions and limitations. And it's all going to be tied together to establish that those symptoms prevent you from doing the material and substantial duties of your occupation. Now, as you're going through this initial analysis, you have to start thinking about what's the right day I want to claim disability. And many people will make mistakes. They will stop working, apply for benefits, and only find out that their medical records aren't supportive or that their doctor won't support the claim. Can't go back and necessarily fix that sort of stuff very easily. The other thing that you need to take into consideration, quite frankly, is having money to live on while this claim is pending, and with the idea that perhaps if the claim is going to be denied and I have to get a lawyer involved, how am I going to live for 6 months, a year, or more? The other important consideration is getting alternative health insurance coverage, because if you quit, you file a claim and you quit or you get terminated, you're going to lose your group insurance. You obviously want to have that alternative insurance in place because you need treatment and because you got to submit proof to the disability carrier on a regular basis that not only you are disabled, but that you are getting a treatment that's reasonable and appropriate. Now, once you've done all of that, you've got to pick the right date to be disabled, and you've got to notify your disability carrier of the claim. I also strongly suggest that you send a letter to your insurance carrier telling them that they can't have any oral contact with your physicians. They can only have contact in writing, and you'd like to be copied with that. Why? because all sorts of games are played by disability insurance carrier, nurses, peer review providers, and other professionals in trying to convince your doctor that you're able to work. Now, you also should send a letter to your physician saying, I only want you to have written contact with my disability carrier. And if you get something from them, I want to be copied on it, and I want to see your reply before it gets sent in. And by the way, don't ever send any of those attending physician statement forms to the carrier directly. Give them to me, and I will submit them. Now, additionally, you probably are going to have to hire a Social Security disability attorney. Why? Because many disability policies say that you have to apply for Social Security disability benefits. And if you don't, they're going to reduce your benefits as if you were getting benefits. ERISA disability claims are tough. Social Security disability claims are tough without having an attorney. I know you've heard that the neighbor next door got their Social Security disability benefits, but they're not you, and every case is different. So you really need to be thinking about retaining both an ERISA disability or a Social Security disability attorney, or a person like me who does both. Now, as you're thinking through this, what are the pitfalls to avoid? 1, don't use unsupportive medical providers. 2, don't lie on the forms. Don't overstate your symptoms. Don't exaggerate. Next, you need to understand your functionality as it relates to the symptoms that you have and how those symptoms impact your ability to function. And so if you aren't truthful with your doctor about what your symptoms are and your functionality, that can be a problem, particularly when the disability carrier goes looking at your social media accounts and sees all sorts of posts about you doing things you said you couldn't do, or doing things that you said you had difficulty doing. That certainly is going to lead to surveillance, and the whole ball of wax is going to be packed up to your doctor and said, and they're going to be asked, well, if you're relying on the history of the symptoms and complaints and rendering your opinions, does this social media post, does this surveillance change your opinion? And more often than not, it will, and your claim goes down in flames. The other pitfalls are not getting medical treatment or not getting recommended testing. Now, they can't make you have surgery, but you need to get medical treatment. And if you don't follow through with that treatment, there's a policy provision that gives the carrier a license to say, they're not compliant with the policy terms, we get to deny the benefits, and courts will uphold that. Now, I don't think you should be communicating with the carrier on the phone. Email, writing, that's the way to go, because it's something that can be tracked. The other thing I want you to avoid is the use of social media. I tell my clients to turn it off. Turn yours off, your spouse's off, your mother's, your grandmother's, your aunts, your uncles, anybody else who's posting about you, it's off. Nothing about you, because I don't want you to set yourself up for surveillance. Okay, so now you've made the difficult decision to stop work and apply for benefits. What you should be doing first is to ask for a copy of the policy or the plan. And you should email, certified mail, UPS, FedEx, fax, whatever you want to do, ask for a copy of that file, that plan or policy. Why? I want it to be trackable, because under the ERISA law, they got to give it to you. Your employer has to give it to you. And if they don't, then I always say, ask again in 30 days and send it email, certified mail, UPS, FedEx, and fax, pony delivery, just so long as the pony can say it delivered the letter, okay? Why? Because if they don't give it to you, a lawyer like myself can file a lawsuit in federal court, and we can get paid for getting that, and you can get money for a fine. It's a $110 a day fine, and attorney's fees are paid. Of course, this is all in the discretion of the court. So once you've got that policy or plan, we're going to be looking at it very closely based on disability, occupation, own occupation, any occupation, mental nervous conditions, subjective limitations, offsets. Those are the key things that you need to understand, because you're going to have to chart your way through the shoals of those definitions. Now, once you file the claim, what's going to happen? You're going to get a letter acknowledging the notice of the claim. You're going to receive forms, and lots of forms. I want you to write a draft and put it down and come back. Be consistent and make sure that whatever you're saying is consistent with your medical records. Now, your employer is probably going to be reaching out to you talking to you about HR issues. Be careful about what you're saying to them about returning to work, not returning to work, difficulties that you are having with your workplace duties. They're not necessarily in your favor. They're in their own corner. You need to understand that you are going to have activity of daily living forms to complete. And to me, they're open-ended questions, a trap, but you don't want to set yourself up for a claims denial by exaggerating or lying about what you've put. Now, you know that they're going to send the APS forms to your doctor, and your claim can be made, won, or lost with those APS forms. So it's really important, as I've said, that you're having a little discussion with your doctor before you stop work and apply to make sure that they're supportive of your claim and are willing to fill out forms. Now, there are 3 red flags in this initial application process. First, if they ask to take your statement, that's a red flag. If they schedule you for an IME, that's a red flag. If they want you to have a functional capacity evaluation, that's a red flag. And you need to take it for what it is. They're not doing this to be nice. They're doing it to set you up for a claims denial. And if any of those 3 things happen, or all 3 happen, you need to get a lawyer. Now, if you're lucky, you'll get a claims approval. But in most cases, there are some preliminary steps that lead to a claims denial. So let's talk about the claims denial. If you get a claims denial, there are steps that your attorney will be expert in managing, assuming that you're dealing with a qualified ERISA disability attorney. You don't want your family lawyer, your Social Security lawyer, your criminal law lawyer, your personal injury lawyer, your Uncle Vinny or Cousin Vinny doing an appeal. Now, you have the right to an appeal, and you need to check the policy to see how many appeals you can do. And there is a mandatory appeal process within 180 days. And if you don't exhaust your administrative remedies by filing an appeal and try to go into court, you're going to lose. Now, the appeal is a trial of your case. My appeal letters are 25 to 60 pages long, and I leave no room for the carrier to deny your claim. I request a copy of the claims file. I review it cover to cover. I'm putting together your case, developing medical evidence, vocational evidence, taking statements. It is crucial that you have assistance, because I want you to remember the sage advice of Abraham Lincoln, who said, a person who represents themselves has a fool for a client. So if you write a letter that says, I'm appealing, you write a letter that's got all sorts of updated medical records, don't really expect that the carrier is going to change their position. It's crucial that we develop the necessary lay medical and vocational evidence that rebuts the basis of your carrier's denial. Now, what happens if your claim denial is upheld? Definitely, if you haven't gotten a lawyer, it's certainly the time to get a lawyer. But you need to understand that in an ERISA case, the appeal is a trial of your case, and nothing new can be added to that claims file. So when you retain an attorney, they're stuck with the record. And basically at that point, their job is going to be to negotiate the best settlement they can based on the state of the carrier file. There's no depositions that well, let me back up. There are rarely depositions, or the depositions are limited as to what you can do. But I can't take the doctor's deposition, your doctor's deposition, your deposition, the deposition of a vocational evaluator. All of the things that lawyers think they're going to hold for the trial have to be submitted in an appeal. So don't make that mistake. Now, how about a lawsuit? You got to file a complaint. You're going to get an answer. You're going to have a case management conference with the attorney. You're probably going to have mediation. And there's ultimately going to be a motion for summary judgment. Those are not things that you should be handling. It's as simple as that. It's like trying to do heart surgery on yourself. Don't do it. So that's an overview of the claims process: deciding to file a claim, filing a claim, dealing with a termination, and a lawsuit. Hopefully you get my point. Let's take a quick break before we head into our next section.